versus Javar Tyrone Grayson. Case number SP 146437761, SP 146409991, SP 1463900, counts 1, 2, and 3. State your name for the record.
Grayson
Bay. I'm sorry.
Thank you.
State your name for the record.
Grayson Bay.
All right. This is today is the date and time set for a jury trial. Ms. Schneider, can you put your appearance on the record, please?
Good morning, Your Honor. Alexis Schneider for the people, P80322. For the record, the issuing officer, Officer Ambrose, was present, although I released him.
Mr. Grayson Bay, we didn't conclude some of the. First of all, I want to get the record straight from yesterday. I did mention, and you did cite. Where's Mr. Grayson Bay's file? Yes, but I brought it back downstairs. Yes. I wanted to clear up something I said on the record as far as the case that you cited out of Alabama. That I was incorrect as far as the facts of that case.
All right, buckle up, because what you're about to witness isn't just another courtroom hearing. It's the final chapter in a saga that perfectly captures the collision between reality and belief. We're talking about Grayson Bay versus Judge Perkins, a case that started with confidence, escalated with defiance, and now ends with consequences. Yesterday, this defendant stood firm on sovereign citizen ideology, throwing around legal terms and case law like he had cracked the system. But today is where the system answers back.
That was not the case where they were walking down the street and did not obtain the license to assemble. That was a case where he had another reverend organized a sit-in and at a restaurant, and they were ticketed. And the unfortunate part about it is, and that's just how our society is, and it was, and still is for the most part, is that this case had to go all the way to the United States Supreme Court for him to get justice on this case. But again, you're citing cases, sir, that you're not even reading.
This right here is something you don't see talked about enough, and it's actually one of the most important moments in the entire hearing. The judge pauses everything to correct his own mistake from the previous day. Think about that. In a system where authority matters, he openly admits he got something wrong about a case and takes the time to clarify it on record. That's how the legal system is supposed to work. Based on accuracy, not ego. And here's where it gets even more interesting. The case the defendant cited didn't support his argument at all. In fact, it showed the opposite.
That's something a lawyer would be can be brought up to the grievance commission on and potentially lose their license. All the cases in there, all the cases that you have cited are saying exactly the opposite of what you purport. Have you looked at any of them?
Yes, Your Honor.
And you read them? When did you do that last night?
I've been studying more science. My religion is more science. As you can see, if it looks like a duck, it acts like a duck, it tells you it's a duck, it's pretty much a duck. So I'm more science. So I've been studying for over. And
but you haven't been studying.
No disrespect to you, Your Honor. I just want to remain mute to the fact and acknowledge that my mother is here, the matriarch of my family, and so I just want to remain mute to this case in this matter. And the floor is yours. This is your courtroom. No disrespect. My mother is here.
No. Ma'am, can you stand up and state your name, please?
My name is Mary Grayson Hall.
Good morning, Ms. Grayson Hall. And I'm not, it's nothing about, you can see it. I just wanted you to acknowledge, I do acknowledge the fact, and I appreciate the fact that you have support here.
Now we're getting into the core issue, and it's a big one. The judge is essentially saying, not only are these cases irrelevant, but they actively contradict the defendant's claims. That's a devastating position to be in. Imagine trying to defend yourself using evidence that actually proves the other side right. This is where things fall apart for a lot of sovereign citizen arguments. There's often a surface-level understanding. Terms like jurisdiction, sovereignty, or rights get thrown around, but without proper legal grounding, they don't hold up under scrutiny, and here's the kicker.
The court always recognizes that. That's why I asked you to stand up. But you want to remain mute now. But you didn't remain mute when you filed these pleadings. This is how you speak to the court, exactly the way you did. Now, maybe the form is not exactly the way the court kind of or the rules have applied, but I understand you're in pro per and you might not know all of those rules. But when you start filing these documentations, you're speaking to the court and you're representing that this is the current state of the law as this is the current state of the law, and this stuff applies to your case, and I should be reading this stuff and be able to interpret what you're saying about your case through these cases. And when I read these cases, it says exactly the ones that I've read, and I've seen these cases filed before, it says exactly the opposite of what you're trying to say. Because what I understand you're trying to say is that you're trying to say that you don't need a valid driver's license to drive on the roads, you don't need proper registration on your vehicle, and you don't need proper insurance. And you're even going as far as saying that the police officers, and correct me if I'm wrong, that the police officers do not even have the authority to pull you over. Is that correct?
Again, Your Honor, I remain mute.
This moment right here is where things take a sharp turn into ideology over legality. The defendant shifts away from law and starts leaning into personal beliefs, talking about science, identity, and how he views the world. But here's the problem. Courtrooms don't operate on personal interpretations of reality. They operate on established law. You can call yourself whatever you want, Moorish national, state citizen, or anything else, but none of that overrides traffic laws, licensing requirements, or jurisdiction. The judge is clearly trying to bring things back to reality, while the defendant is doubling down on identity-based argument.
No due respect to the court, my matriarch is here, and I gave you pretty much documents to read, and I'm standing on those documents, and I'm gonna remain mute. Thank you.
All right, so I've already found you guilty of the count of refusing to exhibit a driver's license, SP 1464091. I'm going to fine you on that case $240. I've already found you responsible on SP 1463901. Expired plate. I'm going to fine you $145 on that. And I've already found you responsible on SP.
Now this is a fascinating contradiction. The defendant says he wants to remain mute, which on the surface sounds like he's invoking his right to silence. But the judge immediately calls it out, because you can't claim silence after submitting documents, arguments, and filings to the court. Those documents? That is communication. That is speaking to the court. And once you've done that, you don't get to selectively opt out when the conversation becomes uncomfortable. This is a critical misunderstanding. Rights like remaining silent apply in specific contexts, but they don't erase everything you've already put on record.
14639-003, insurance no proof, and I say guilty on SP 146409991, and that's a 240 for the insurance no proof. I'm going to fine you $195 on that. All right. As far as the other counts, I had the note. Well, you told me off the record that you're going to dismiss SP 146436761 and SP 14639-002. Is that correct?
That's correct, Your Honor.
So 145, 195, and $240, sir. When can you pay?
I would probably need after the holidays, maybe 3 months. I might get something up for you.
Are you working?
I do carpentry.
Yeah, you do carpentry. Are you working?
Yes. Yeah, I have jobs lined up.
Okay, so why do we need so much time?
They lined up. They're not completed. They're just future jobs that I've lined up.
This is the moment where the judge lays everything out clearly. No confusion, no ambiguity. Driver's license, registration, insurance. These are legal requirements, not suggestions, not optional, and definitely not overridden by personal interpretation. The judge even summarizes the defendant's position and asks for confirmation. But instead of answering directly, the defendant falls back on silence again. And that silence? It speaks volumes. Because at this point, the court isn't debating anymore, it's confirming facts. And when you refuse to engage with those facts, the outcome becomes inevitable.
So presently, you're not working.
Today, I'm not in court.
You got this play on words.
Yeah, I mean, traveling and
Is this
driving. Yeah, there be the system. Play on word. I mean, it's the truth, though. I mean, I got to speak the truth to you, right?
You're
respect
not
the truth?
working now. If you,
Okay, I'm not working today. I'm not working.
No. You're not. I'm asking you, why is it taking 3 months to get up? I don't typically give out 3 months to pay fines, especially when somebody's working, and especially in a career that's a skilled trade, that's a very lucrative career. So I'm trying to give you the time you need, but I need to make a good basis for that.
3 months.
Because you're not giving me a good basis for giving you 3 months, and you're telling me you're a carpenter and you're telling me you're working. Now, if you're telling me you're a carpenter and I'm not working currently, then that's something that I can go with. But you're telling me I'm just not working today.
Right.
I'm gonna go to work tomorrow.
Well,
I'm going to work tomorrow, and I'm going to work the next day.
Yeah.
So I'm not giving you 3 months.
Very
for that.
optimistic. That's why I say, well, as this present, not, but yeah, tomorrow. I'm very optimistic about work. So yeah, yeah.
So you're not working.
Today I'm not working. Tomorrow I'm going. I have grass work tomorrow to do. There are schedules.
Now we shift from ideology to practicality, and things don't improve. The judge starts asking simple, straightforward questions about employment and payment ability. And what we get in response is confusion, contradiction, and a lot of wordplay. At first, the defendant claims he's working. Then he's not working. Then he has jobs lined up, but not really. And this back and forth creates a credibility problem. Because in court, clarity matters. Consistency matters. The judge is trying to determine a reasonable payment timeline, but without clear answers, that becomes impossible. And when the court can't rely on what you're saying, it defaults to what it can verify.
To do, and I do have a future as a job to have things to be done. But as you saying, as I'm working, I'm telling you the truth, not as now. No, if that clears, if that makes you feel comfortable, no, I'm not working.
I'm trying to get ascertain.
No, I'm not working. I'm not working at this present moment. I'm not working.
And when you say you're working, you have some aspirations of
yes,
working to, like everybody does. We're looking for, well, not everybody, because not everybody is trying to work.
Right, exactly.
So you're not working now, correct?
Right. Thank you, Your Honor.
Let me ask you this, ma'am. Is this the kind of, I don't know, I want to make sure that you don't need any mental health services? Do you? You're giving me all of this
speak
stuff.
The truth, Your Honor. I don't speak the truth.
I don't feel you're speaking the truth to me.
I'm not working. today, at this present moment, I'm not working.
And you're not working, you don't have anything set for tomorrow,
No, I don't.
right?
Nope, I don't. I don't.
You don't,
I'm
do you
not
have
even
anything
working.
set for next
No.
week?
No, I'm just anticipating things. You're right, I don't.
Do you understand what I'm saying?
Exactly, exactly.
I'm gonna give you, I'm just gonna get you out of here. I'm gonna give you, till March the 5th. You can either Zoom in or come in. I'm gonna give you till March the 5th to have this stuff paid off, all right?
Could I get a total of that?
And just like that, the entire argument collapses in a single moment. After everything, the claims, the resistance, the refusal to acknowledge the court, the defendant asks for the total amount owed. That one question changes everything, because by asking it, he's recognizing the court's authority. He's acknowledging the fines. He's accepting the outcome. And whether he realizes it or not, that contradicts everything he stood on throughout the case. This is the reality of situations like this. Belief can be powerful, but it doesn't override the law. And when tested in court, only one of those holds up.